Cloud. Okay, I think we're good. So let me turn it over to you, Stephen, to get us started.
Sure. I mean, typically how we go through this here is we just want to do a brief introduction, and usually I think we have Johnny run through the opening here. I think I'll take the opening on this part and let Johnny introduce himself as well. But we are employment law attorneys with the law firm of McAllister, Detar, Showalter, and Walker. We have offices up and down the Eastern Shore and now in Annapolis as well. The focus that we've been doing as we've kind of gone through this period is identifying the areas and the hot spots of employment law issues in the workplace as you sort of come back into having a throttled up workforce after the kind of quarantine and the stay-at-home orders are lifted across the counties for our state. So with that, I'll let Johnny introduce himself here, and then we'll get into it.
Great. Thanks, Stephen. Great to be here with everybody. Two lawyers, too many is, I thought the joke that we were going to hear, but luckily Mark restrained himself, so I thank you for that. Any event, like Stephen said, we do labor and employment law exclusively. It's a real passion of ours. This is a chance for us to geek out a little bit together, share some of our knowledge with you and some of hopefully what we think is best practices and very practical advice. Clearly, Mark was discussing it, that we are in a new normal. Could change any moment. Nobody's really certain what's coming next. We've been really harping on a theme here in when we do these presentations to employers and employees alike, is that the golden rule is always a great fallback. When in doubt, follow the golden rule. Always treat people the way you would want to be treated if everybody's situation was switched around. Anyway, Stephen and I have spent a lot of time. We're up to date on all the latest state and federal, local laws and ordinances and guidance on the COVID situation and employers and employees coming into the workplace and some of the best practices. We plan to talk for about an hour. We think that it's always best to have audience participation, questions, scenarios, because you all are out there living it on a daily basis. If you have a question, it's probably a question somebody else has. We'd love to do scenarios. If you have any in the middle of the presentation, I think there's a chat function here or a raise your hand function, and we can get to that. And it'll keep it interesting instead of Stephen and I just droning on. But anyway, I'm going to throw it to Stephen now for the first substantive slide and let him have at it. Stephen?
Yeah, so thanks. So what we're really looking at here is trying to figure out what uniform type of advice you can get across businesses. So one of the big things that we start from in this moment is the Occupational Safety and Health Act. Now Maryland has its own, but it does defer a lot to what the guidance that we're seeing come from OSHA here. And what we're looking at are essentially these 4 points. And if you read through some of the stuff that the state of Maryland has spit out, like for example, on Thursday of last week, the governor's office through the Commerce Department spit out a best practices for restaurants reopening. And they went through a whole bunch of different things that restaurants should be thinking about and what they can do to ensure sort of a safe implementation of this outdoor seating option that's now available. And if you look through to where they kind of worked it through, you'll see these 4 points. Identify where, it's developing a preparedness plan, implementing basic prevention efforts, develop certain policies for how to handle if somebody gets sick at work, and develop and communicate flexibilities and protections. And you'll see them implemented throughout. It's, in terms of developing a preparedness plan, you just need to look at your workplace. Where are the risks coming from? You're going to want to really think hard and be creative about, are we a high public interaction business? Are we a place where we have a bunch of people coming through the door? Well, we need to think about how we handle each of those people. What are they touching when they come in? Are they talking to us? Are they meeting with us? And how are we going to put up protections between our employees and that population? On the other hand, if you're an isolated workplace, if you're a warehouse where the public isn't coming in, you're really just looking inward. How are we keeping our employees individually spaced and protected? And you're going to hear a lot of people talking about, plexiglass barriers between employees, and making sure there's additional spaces and staggered schedules. Those all play into the implementation of prevention efforts. Is what now what your risks are. Now be creative about how to solve them. And then these last two really deal with being able to turn on a dime if you find out that somebody's sick in your workplace and is demonstrating the symptoms of COVID-19. You need to be able to isolate them and be prepared to identify who came in on their shift, who had they potentially interacted with. Is this a situation that we're going to have to notify local authorities? So you need to have a plan in place for identifying the issues, how to handle them and how to lower the risk, and then how to handle it if somebody does come in and get sick. And ultimately, the flexibilities and protections are really have a flexible workplace sick leave policy. If somebody is sick, you want them to be working from home. So you want to have them to have the opportunity, and you need to be flexible to do so. So with those 4 pillars, that really is how you kind of look at and assess your own workplace in providing a safe workplace. This next slide addresses 3 sort of general issues that we're seeing as employers sort of get spun back up after potentially laying off or having a furlough. First is unemployment. 2/3 of the people receiving unemployment benefits are likely being paid more on unemployment than they were in the actual workplace. So that creates an automatic tension between people who are getting paid more now for being safe at home than coming back and getting paid less to come in the workplace. So what you need to do there is simply, you need to be prepared to have that conversation and understand what that tension is, and be able to have a forthright conversation with your employees and when you're bringing them back on board. One of the things we're recommending also falls in line with the guidance for PPP recipients, is that if you have a worker who doesn't want to come back, you need to make a in writing offer of full employment back to that employee at the rates and payments and every terms and conditions that they had before, and put it in writing to them and document if they refuse that order. In that letter, you should also inform them that there's a high likelihood that they're going to be disqualified from unemployment if they refuse to come back. So that's one of the things that you need to have in place there. And the reason why it's important for PPP recipients is because it allows you not to have that person who refused to come back count against your lost FTE. So there's that part. And the second point here is the non-compete, non-solicitation agreements. There's certain wording in those types of agreements that if you terminate employment through a layoff, for example, you may trigger the time period of protection that you had. So you need to go look at those agreements and see if you triggered the termination provisions in those agreements. And if you did, when those employees come back on board, you need to have them re-sign in order to make sure your business is protected. And finally, on this page, we have review your CBAs and your employee handbooks. A lot of folks have onboarding policies, have different accommodation policies, things like that. You're going to need to make sure you follow your established policies as you bring people back in the door, or you need to make sure that you do very quick and prompt adjustments to those policies so that you don't run into a conflict with your employee where they're pointing at this, whatever policy you have in place, and you're sitting there with your hands in the air wondering why you didn't follow it. It creates a little bit of a legal tension at the end of the day if they have something else to come after you for. So pay attention to the policies you have in place, make sure your agreements are enforceable, and make sure you're delicate in your conversation with the people you're bringing back on board. And with that, I'm going to flip it back over to Johnny here to run through some more points.
Great. Thank you, Stephen. I appreciate that. So, Stephen's talking about getting spun back up, and the next step is when the employees come back in the door. So, I think in this scenario, one question is, should you pre-screen? You have a legal right to pre-screen. That's what all the guidance, CDC, Department of Labor, Equal Employment Opportunity Commission are telling us. I think the better question is, should you? And I think it's dependent upon your personal situation of the business and what your abilities are. Because if you're going to test one, you need to test all. Stephen really brought up a good point there on following your policies and procedures. And the reason why is we have to treat everybody the same. Discrimination is defined as treating similarly situated people differently, and we want to avoid that scenario. So just like following your onboarding policies and procedures, we want to follow the rule of consistency. If we're going to test one, test all. So I would say it's certainly prudent, I think, to try and do some of the temperature testing if you're capable, have enough manpower to do that and the resources to do it. You cannot go wrong with some of the basic level of testing. I think in the event, the bare minimum should be that you ask your employees to voluntarily disclose if they've either had COVID or symptoms or been near people who have had the sickness or symptoms of it. If an employee actually does voluntarily disclose, hopefully everybody's familiar with the Americans with Disabilities Act and is familiar with the concept of reasonable accommodations. We would treat a scenario where somebody discloses that they've had COVID or an exposure to COVID as a request for a reasonable accommodation. Stephen talked about this earlier. One of the ones would be to do work from home instead of work from the office. So again, document the entire process, the entire way through it, and engage in the interactive conversation to find a reasonable accommodation. The reason why Stephen was also suggesting that we put things in writing and make offers of employment is because under the law, you have more rights to engage in quote unquote medical testing of employees when there's an offer of employment than when you do if there's just existing employment. For example, hiring somebody, you can require post-offer drug testing. You can also now require post-offer COVID testing that's more invasive than what you could do compared to when you just promote somebody from one position to another, or have somebody who's a current employee and then was out on a leave coming back from the leave. So that's why we want to, one, document everything, two, and be really formal and make contingent offers of employment that would allow you to handle medical testing. I think the other thing is when people return to work is that if somebody is sick, Stephen said this, ask them to go home and remove them from the workplace. I would have a function where you're able to communicate to the other workers that there was somebody at work with the symptoms or the actual diagnosis. Do not use names. Confidentiality is a legal requirement here. We have to protect people's identity and personal private health information to the greatest extent possible. Also, if somebody is sick or had the symptoms of it, you can require doctor's notes before returning to work. Stephen's going to get into this in a little bit more detail under the ADA, but the guidance from the federal government is very clear that if somebody has been out related to COVID, we are allowed to require formal documentation that they're clear of symptoms and okay to return to work. And then I just want to finally reiterate again, Stephen hit on this before, is that discrimination on several bases is called protected classifications is prohibited by law. There's nothing different related to COVID. The same restrictions apply, and which is why we're saying be consistent and treat people similarly, because state, federal, local laws all will have different provisions prohibiting discrimination. So on that, I guess I'm on my next slide here, if you don't mind. Thanks, Stephen. Again, people at work getting sick, again, protect, preserve confidentiality. I'm sure everybody would want their privacy respected if the shoe was on the different foot here. And I also caution something Stephen said is have some latitude. If there was an exposure in the workplace and some of the coworkers feel uncomfortable and want to go home and work from home and you're able to do it, I would encourage you to have that latitude. Stephen talked about having the flexible and nimble workforce. I think that has never been more true than in today's world. And then if there is something in the workplace, I would say clean, and then clean some more, because that's proven to be scientifically the best way to address these issues. Workers' compensation has been a subject a lot of people have talked about. It is right now a big question mark in the state of Maryland. Other states have been much more active proactive in addressing workers' compensation. For example, in New York, if you can establish a workplace exposure, there's a presumption that anybody's sickness is going to be a workers' compensation coverable event. In Maryland, we don't have that, and it's a big unknown. I would encourage, and Stephen and I have been telling all of our clients this, that if you think there is a COVID work-related sickness, you should call your workers' compensation and carrier, ask them to honor the claim and cover the claim. I don't know what the outcome is going to be of this yet. I suspect our governor has been pretty strong, and I think he will act on this issue. But the best advice right now that we tell everyone is to try and get workers' compensation insurance to cover any event. And then the other big new law here in this scenario is the Family First Coronavirus Relief Act. And I'm going to kick it to Stephen so he can take you through all those process and procedures.
Thanks, Johnny. So here we go with the Families First Coronavirus Response Act came out first among the legislation we've seen. You know, the CARES Act gets all the attention due to the financial implications of that. But what I think we're going to see as people come back into the workforce is the implication of this act because of the leave requirements that it provides. So before there's this exemption to this rule that says if you don't have the work, you don't have to provide the leave. So if workforces are scuttled and people are either not working from home or are, you know, there isn't work to be done and you're closed up, this doesn't really come into play. But as you try to open up and have the people back in the workforce, you got to be keenly aware of what obligations you're going to have if an employee comes to you with a request for leave for one of the variety of coronavirus related issues. So first, the FFCRA provides two different types of leave. It provides emergency paid sick leave, which is 80 hours of leave for an employee based off of a number of different circumstances tied directly to COVID. The second part is an expanded Family Medical Leave Act portion. That one applies to people who don't have child care and need to take leave in order to care for a minor child due to the closure of their school or child care provider. That's paid at 2/3 of their regular rate for a period of at least per period of 10 weeks out of the normal 12. And that right there is something that's job protected at leave. You have to keep their job protected and pay the 2/3 portion for that period of time that child care is unavailable. Now, within this bill and within this legislation, it is designed to have a tax credit to cover your expenses related to it. Of course, our asterisk is C your CPA because we want to make sure that you're following all the steps that will entitle you to that reimbursement through the tax credit. There is also a poster that comes with this that needs to get out to your workforce either remotely, so email it to all of them, or once you have people coming back into the workplace, you need to post it prominently. And I'll show an image of that poster in a second here. Also, it has anti-retaliation provisions. So if you do have an employee who asks for the leave and you were to fire them instead of, for example, giving them the leave without even taking a look at it, you're running the risk of having an anti-retaliation lawsuit brought against you. So you need to be very keen in paying attention to the leave requests that you get and documenting them properly and making sure that you're not taking adverse action against these employees without a legitimate basis for doing so. And finally, there are exemptions to this. Healthcare providers, for example, are a massive definition of exemption. Any employee of a doctor's office is considered a healthcare provider under this. Anybody who contracts with a doctor's office is considered a healthcare provider under this. It is an extraordinarily broad definition. On the flip side of that is the small business exemption for employers who have 50 or fewer employees who can demonstrate that if offering this leave would destroy your ability to continue as a going concern, you don't have to provide it. Or if you are going to have to provide it to an employee who's so essential to the ongoing business that you have, that if you were to provide it, you would go out of business, then you don't have to provide it. Those bars for those to hitting those two exemptions are so high, it's practically impossible to hit them unless you can document it through You probably want to have your CPA review your account statements and your profit and loss numbers to be able to demonstrate that truly your business would go out of business if you were to pay the specific amounts that would be required under this law for the paid leave portion. This here is the poster. It's available online at the Department of Labor's website. We're happy to provide it to anybody who needs it as well. So as we go through this, if anybody has follow-up questions at the end, just shoot us an email. We'll make sure we get it out to you. But as you can see, as you walk through this, it has 6 different very specific areas for coronavirus leave. And if somebody doesn't fit into those leaves, then we're back into normal. What type of leave does the state of Maryland require you to provide? When we're talking about documenting things, I'm not going to go through each one of these, but this is word for word from the IRS's website about what they want to see in order to justify the tax credit that you'll get in order to substitute or supplement for the expense that you see for providing this leave. The reason I bring this up is because if we look down at the bottom, there are some really, well, hang on, some really unique areas here. For example, if you're requesting leave for a school closing or a child care provider, you have to represent, they want to see a representation that nobody else would be able to care for this child. So in that setting, for example, if you're a husband and wife at home, both working from home, and who else can care for this kid? Well, can my wife or my husband care for the kid? Well, I don't think you should be overly oppressive in requesting information to substantiate these things. While they're being requested and this information is requested, I would simply ask for the employee to sort of give you the nuts and bolts of what the situation is so that you can document it. The other one that's pretty unique about this is that while the law simply says minor employee, so a minor child, anybody under 18 years old, the IRS goes a step further and says, if you have a child who's 14 years old or older, we want to know what special circumstances exist why you have to basically miss work to care for that child. Again, our standing rule kind of derives from the golden rule of, essentially be kind, really. When we're looking at this, don't look for reasons to deny the leave. Look for reasons to properly support it, properly document it, and just get the information necessary to get your tax credit. You don't need to, again, go into and be judge, jury, and executioner on whether you believe their special circumstances they provided you are sufficient or not.
Let me interrupt you real quick. Sorry, Stephen. There was a question that came in about the poster. I don't know
sure.
if you saw
I'll go right back.
So for everybody's benefit, in case they can't see it, the question is, if we are in a healthcare exemption, do we still have to get the poster out to all employees? Stephen, what's your take on that?
It's a outright exemption. Now, one of the things that so it came out in an added definition that expands the definition of healthcare provider under the FMLA. The traditional FMLA was what you would imagine a healthcare provider to be, a doctor or a nurse or something like that. This expanded definition is something that's very unique. After the definition itself, it says you may offer this leave if you wish. So the problem with that is if you have a large employer, getting people to uniformly make the decision and make objective decisions across your employment base as to why some people would get it and others wouldn't creates a massive litigation problem for you from a discrimination standpoint that is really a can of worms best left either 100% on or 100% off. So if you're a healthcare provider, and this is my position, I'm certainly Johnny chime in here, but if you're sitting there and you're saying, as a healthcare provider, I'm going to make the conscious decision to provide this leave, you can. And in that moment, I would give the poster out. But so far, what I'm seeing is that that the healthcare providers that I've represented are making the blanket decision not to provide it. And in that case, there's not an obligation to provide this poster.
Yeah, I think the way I took the question was slightly differently and much more elementary than you, because you're smarter than I am, but whether you just have to post it or not. And my advice would be, yeah, put the poster up, take the position Stephen was discussing about whether the exemption applies or doesn't apply, but everywhere you have all your other workplace posters, I would put this one up. And then, as Stephen suggested, this nuanced definition may or may not apply to your situation, and you may want to change your position that once you try to offer it and then it becomes burdensome. Stephen said, maybe you decide that you don't offer it. But I think the legal requirement to put up the poster where you put your other posters would apply.
And one good example of that would be if you look at your wage and hour poster, almost all of the wage and hour posters talk about tip credits and tip requirements. And I'm sure if you're a healthcare provider, you are not going to have one of those. So the whole point with that,
Hopefully not.
the over posting of information is certainly not something that in the past we've gone past on these posters. I think that leaves me. I guess the only part that I would want to point out on this slide here is in order to get that tax credit, there's certain records that the IRS is going to want you to create as the employer. How did you make the decision to come up to permitting the particular employee that you granted leave to have that paid leave? And so this slide here gives a little bit of information on what the IRS would want to see and what type of documents they'd want you to use to substantiate that point. And with that, I'll flip it back to Johnny on some of the other stuff.
Great. Thanks, Stephen. Really good and important advice, showing the importance of being up to date, following all these regulations the government is putting out, it seems daily, if not weekly. I want to just remind everybody that the Family and Medical Leave Act still applies in these scenarios. Stephen was talking about these two new coronavirus only laws. Even where one of the two provisions Stephen was discussing may not apply, the Family and Medical Leave Act is still something that you should keep your eye on. Stephen talked about the Emergency Family Medical Leave Expansion Act, and that is part of the FMLA. And so my pointer to everyone today is that you get 12 weeks total under both of these, the Emergency Family Medical Leave and also the old, as we know it, FMLA. Stephen was talking about the new expanded version for the family care provision has the 10 weeks in it. So if somebody were, for example, to use the full 10 weeks under that provision, that would mean for the remainder of the FMLA year, how you normally count it, they would only have 2 weeks left for any traditional FMLA issue, serious medical condition, for themselves, somebody else, birth or placement, adoption of a child. Just want to caution you that those two, it's a 12-week total for 1 year, however you measure it. Again, Stephen mentioned this too, but if somebody is laid off or there is no work, they're not entitled to the FMLA leave or the Emergency Family Medical Leave Act leave, or Stephen talked about the emergency paid sick leave. If somebody is not working, they're just not eligible. Job restoration, Stephen mentioned that too. Again, it's to a same or equivalent position. These are just concepts everybody should be familiar with to remind you about. And that's because the FMLA is still out there. You still need to abide by it. It's been added to by the emergency FMLA, but all of our old issues still remain. And it brings to me something I always tell clients, that if you think there could be an FMLA situation, send out the paperwork. When in doubt, send the paperwork out, is what I tell people. You have a statutory 5-day period to send out the paperwork. If you have reason to suspect the FMLA may be implicated, just send it out. If somebody's eligible, Stephen mentioned this too, is we want to help them get the leave they're entitled to. And if they're not eligible or they don't want it, they won't return the paperwork. But the important thing is you will be in compliance with the law by sending it out. On the next slide, we threw this in here to remind everybody, not only are there the federal laws that you need to comply with, but there's state laws. And Maryland is notorious for this. There's the individual county laws, several city ordinances that you have to comply with. So there's really at least the state, federal, local levels that you should keep your eye on. We're happy to deal with everybody on an individual basis, depending on the jurisdiction you're in. But just remember, there could be some local jurisdictions that might be issuing laws that you need to comply with. Most oftentimes it's based on the amount of W-2 employees you have. So I would look at it from the standpoint of the W-2 employees as opposed to independent contractors that get a 1099. I'm hoping and keeping my fingers crossed that everybody knows when I'm using those terminologies, that the difference between the two. I will kick it back to Stephen here for some other very important payroll issues, right?
Yeah, so one of the kind of things that sort of slips through the cracks, I think, in this moment is everybody's attention is on, how do they get their workplace back open? How do you get the financials back? How are you handling your PPP funds if you're able to get that? And there's a lot of things going on to distract you from something that kind of can build and catch you, let's say, years from now. And what I mean by that is your wage and hour issues are something that sort of creep in and don't really care about the work environment or the political environment or even the health environment that you're dealing with. And some of the questions that we've seen first, for example, can I reduce a pay rate? So when people were initially dealing with how are we going to handle the downturn, and now how we're bringing employees back, how are we going to be able to sort of have our revenues match the expense? Can I reduce their original pay rate? Well, under the Maryland Wage Payment and Collections Law, you have to provide at least one pay period's notice before you can adjust somebody's pay period downward. So if you're going from $40 an hour to $20 an hour, from $2,000 a week to $1,000 a week in salary or something along those lines, you must provide some form of notice to the employee, wait a pay period, and then begin in the first pay period that happens after that point. The other issue is, what about salaried exempt employees? The real question here comes into play with, when they work, how to pay them, if you can trace quantity and quality of work. You really are stuck with this rule that if they work some, you pay all in a work week. So if you have a salaried employee that's working at least some portion of the work week, you have to pay their full promised salary. So that's the question mark that a lot of people run into. So we're seeing both the question of, well, if the salary is too high or I can't afford that salary, you obviously check and see if you have some form of a employment contract that would preclude you from making an adjustment to their salary. But if you were to make a reduction in salary, you have to give them one pay period's notice. Or we're seeing the other side of it is 1 week on, 1 week off. That is a relatively dangerous strategy. If they start checking their emails and their work week off, then all of a sudden it might trigger the issue to have to pay them. Overall, with wage and hour issues, it's really about documentation. If you have the ability to track the time the employees are working, that will be the silver bullet to attack or to defend yourself from the wage and hour lawsuits. Because the way these lawsuits work is typically somebody gets upset at being terminated and they Google, I don't think I was paid everything. And they find one of several plaintiff's attorneys who handle these types of cases these days. And they write a letter that says, I believe I worked 90 hours a week for the past 3 years. And if you have the records to, show that that's not accurate, hopefully that's not the truth, but, hopefully you have the records that demonstrate that it's not accurate and they worked and they were properly paid, then that lawsuit goes away there before it even starts. But if you don't have the records, the law provides that the employee can essentially testify and say, well, I believe and I recall that I worked, 1 million hours. And if there's if they can prove that by what's called a just and reasonable inference, meaning, well, I got to work at 8 o'clock in the morning and I left at 8 o'clock every night and I did a bunch of work in between and I never got a lunch and I worked 7 days a week, all of a sudden it starts to kind of shift the burden to the employer. And if the employer doesn't have the rule or the documents to counter that, the court can just adopt the time estimates that the employee has presented. So that's where these lawsuits get dangerous, is in time tracking. So make sure whether your employees are working at home, in the office, on site, off site, whatever the case, that you have a bulletproof way of tracking their time. And with that, here is our wonderful photo op slide for everybody's benefit. And I think at that point, we can open it up to any additional questions anyone has. Or doesn't have.
I I think Mark just jumped off. So if you do have a question, type it in the chat because I can't unmute anybody.
Ah, that will do it. Well, do we have anybody having any questions? I'll put this back up. Well, here's what I'll say is if folks do ultimately have questions, you can see our contact information on here. And I expect most of you have Amy's or Mark's contact information at the chamber. You know, if you're in doubt, pick up the phone, call some of the resources that we have. Mark and Amy are great resources at the chamber to be able to direct you to some of the available portions in the county opportunity here. So let's see here, sharing the slides. I would happily send the PowerPoint in, I think I can get it to you in PDF form for your HR director, Catherine. And if there's any specifics that, you know, questions that you have, by all means, let's chat. So why don't you, if you could, Catherine, shoot me an email at my email address down below and I'll respond with it. And then if you guys have any follow-up questions, I'd be happy to address them at that point.
I'll take it too, Stephen, because we had a bunch of people that RSVP'd but didn't make it on there. So I'll send it along with the recording of this to those people that were interested, for sure. And we've got a YouTube channel that I've been compiling all of these webinars on. So
I want to be on YouTube. I gotta tell my kids to go find me. They watch everybody else.
Right? Mine too. Yeah, you can be a YouTube star.
Famous. This is great. Well, Amy, if you could likewise shoot me an email as well, then I can respond to that as well and get you a copy of
Then
it.
send out a link to your YouTube channel, please.
Yeah, I want to be able to see what we're doing with here.
Absolutely. All right, awesome. Well, thank you guys so much. That was great information. I wish we had more people on here to hear it, but I think you're going to get lots of clicks on the YouTube channel.
Yeah,
So,
and you know what? We've been telling everybody this thing is so fluid. We're happy to do a follow-up. I mean, the guidance is going to change. That's the one thing that I feel pretty confident about. And if we need to reconvene and do this in an updated version, we've already been talking about starting that. We'll set a date and time and we'll redo it.
Yeah.
you know, one question that I've seen a lot with the restaurants now starting to open, but only being able to open carry out, is with the unemployment and people that are on unemployment, you know, making a good amount of money, and then they get asked to come back, but we have a job for you, but it's only to help handle carry out. Well, I was a bartender and I was making a lot more money than what you're asking me to come back to do. How do you address that if they get a job offer, but it's not the same job and it's not the same amount of money that they were making? Can they say no and then they lose their unemployment? How does that work?
It's definitely the risk is certainly on them when it comes to them refusing that particular work, because there is certifications that go through, and depending on what's being offered, it could disqualify them. I mean, the traditional model is if work is available to you and it's comparable to what you had before, you kind of have to take it. So it creates a moment where they're probably going to get disqualified if it's the same employer providing something. I mean, I recognize that a bartender, you know, working a Saturday night in the middle of 2019 is probably going to make a lot of more money than the bartender today, you know, whether they're doing, you know, curbside pickout runs or whatever the case. So the tips are going to be substantially less. So they'd probably have an argument to not be disqualified, but I think it's a pretty high risk move for them. One of the things the employer can say is, you know, for example, that unemployment benefit is, as of right now, could get extended, but as of right now, it expires at the end of July. So, you know, it might be nice for right now, but come the end of July, you're going to really wish you had a job. And if I fill that job that I'm offering you right now, I don't want to be like this sort of evil overlord here, but if there's a job that's available that has a longer term approach, your financial longevity is probably better suited by taking the job than staying on unemployment for something that's sort of an uncertain, it has a certain deadline right now, but it's uncertain whether they're going to extend it.
Right.
Yeah, I would just add to that. I think Stephen's right. The key is whether it's comparable. And the battle is going to come whether the job you're offering them is the same or comparable to what they had. And to further what Stephen said, to encourage people, they can get partial unemployment also. It's not an all or nothing. So Stephen's example is, hey, look, you've had a job here. I'm offering you some work. My opinion would be that it would behoove you to come back maybe at half the rate and get half of unemployment than to take the gamble of telling me you're going to sit at home and wait for this expiration of the extended benefits and hope that I'm still here with the job when you decide to come back, because that is a risk.
Yeah.
Got it. All right, cool. Thank you.
Our pleasure. Great to see everybody. Thanks for having us on.
Thanks
All
so much,
right.
everybody. All right.
Thank you guys. Stay safe.
You too.
Whoops.